Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company, and this is the second part of the video of kinds of contract, and we'll be resuming the video with void contracts. So let's start. Literally the word void means not binding in law accordingly. A void contract implies a useless contract which has no legal effect at all. Such a contract is a nullity, as for there has been no contract at all. Section 2 clause J defines a contract which ceases to be enforceable by law becomes void, which it ceases to be enforceable. It follows from the definition that it is not void from its inception and that it is valid and binding on the parties when originally entered but subsequent to its formation it becomes invalid and null and void of with regards to the legal effect because of certain reasons. The reasons which transform a valid contract into a void contract as given in the Contract Act are as follows. For the first one is supervening impossibility, which is given under section 56. A contract becomes void by impossibility of performance after the formation of the contract. For example, A and B contract to marry each other. Before the time fixed for the marriage, A goes mad or insane. The contract to marry becomes void. The second one is subsequently illegal. A contract also becomes void by subsequent illegality. For example, A agrees to sell B 100 bags of wheat at rupees 650 per bag. Before delivery, the government bans private trading in wheat. Hence, the contract becomes void under this situation. So further moving ahead, the third one is the repudiation of a voidable contract. A voidable contract becomes void when the party whose consent is not free repudiates from the contract. For example, M by threatening to murder B's son makes B agree to sell his car worth rupees 30,000 for a sum of rupees 10,000 only. The contract being the result of coercion is voidable at the option of B, but B may either affirm or reject the contract. In case B decides to rescind from the contract, it becomes void. Then further moving ahead, in the case of a contract, of a contingent contract on the happening of an uncertain event or uncertain future event, if that event becomes impossible, a contingent contract to do or not to do something on the happening of an uncertain future event becomes void when the event becomes impossible under section 32. For example, A contracts to give rupees 1,000 as a loan to B if he marries C. C dies without being married to B. Hence, the contract becomes void. So, the next kind of contract is the void agreement. So, according to section 2 clause G, an agreement not enforceable by law is said to be void. Such agreements are void ab initio, means they are void from the starting, and which means that they are unenforceable right from the time they are made. For example, in agreement with a minor or a person of an unsound mind is void ab initio because a minor or a person of unsound mind is incompetent to contract. Further, the agreement does not give rise to any legal consequences and is void ab initio. In the eyes of law, such an agreement is no agreement at all from its very inception. There is absence of one or more essential elements of a valid contract except that of a free consent in the case of a void agreement. Thus, an agreement with a minor is void ab initio as against him because a minor lacks the capacity to contract. Similarly, an agreement without consideration is void ab initio. Of course, which is with certain exceptions as laid down under section 25. Further, certain agreements have been expressly declared void in the contract act. For example, agreements which are in restraint of trade or of marriage or of legal proceedings, or which by way or wager. A void agreement should be distinguished from a void contract. This is where quite important, because a void agreement never amounts to a contract, as it is void ab initio. But a void contract is valid when it is entered into, but subsequent to its formation something happens which makes it unenforceable by law. Which notice that a contract cannot be void ab initio, and only an agreement can be void ab initio. This is the main point of difference between a void agreement and void contract. Further, obligation of a person who has received advantage under void agreement or contract that becomes void. In this context, section 65 lays down that when an agreement is discovered to be void, or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore. Thus, this section provides for restitution of the benefits received. So this was the concept and the kinds of contract under the Contract Act, and I hope I was able to explain the topic in the two parts of the two video presentations. So thank you.